Welcome everyone to the second of our two professional liability webinars on the topic of breach of fiduciary duty. So last Monday, the 7th of June, many of you attended our webinar that was hosted by Claire Stanley, Lexa Hilliard QCs, James Walmsley and Casper Bartscherer. So they started us off with a discussion about fiduciary duty claims. They tackled the decisions in Bristol and Western Mothew and Paragon Finance and Thakrar, and they went on to draw analogies with breach of fiduciary duty claims against directors, and to ask why these claims are so rarely pleaded against professionals. And we're going to continue that theme with a slightly different focus today. Our seminar looks at what are the benefits of pleading breach of fiduciary duty claims against professionals. So how useful in practice are these equitable alternatives to contract and tort claims? So if you have a case where a professional appears to have been careless in dealing with a transaction, you want to think beyond those claims in negligence in contract and tort and look at the possibility of claiming inequity, because there are some advantages if you're able to do so in terms of remedies available and the restriction on defences that can be pleaded to those claims. Now, for those of you who didn't have the chance to attend our last seminar, don't worry, it's all recorded for posterity. You can view it on our YouTube channel. This seminar is also being recorded and it's going to be put on our YouTube channel. So if you get distracted for some reason or you want to enjoy it all over again, you'll be able to find it again there. And for those who have signed up today, we'll be circulating later on a short handout which will have on it a list of all the cases to which we refer, with a very short summary of the point that was made about it during the seminar. And I hope that's going to be useful for you. We're going to talk about quite a few cases along the way, so don't feel you've got to be alert to taking down or remembering the names of the cases. So joining us today, we've got Jonathan Seitler QC, who I'm sure really doesn't need much of an introduction, but I thought I would flag for you that Jonathan was leading counsel in the Ross River and Cambridge FC case back in 2007. And that was a seminal case that laid down the principles of how you go about establishing the existence of a fiduciary duty in those situations where the relationship really doesn't fall into one of the established categories. So Jonathan obviously has impeccable credentials dealing with all things fiduciary. He's going to start us off by setting the scene a bit, getting us in the zone, thinking about breach of fiduciary duty claims. I'm going to follow on from him and talk about the difficulties with these claims, but also one particular benefit to pursuing them if you can get them off the ground. Also joining us is Lemuel Lucan-Wilson, who's currently working with Claire Stanley QC, defending a multi-billion-pound claim, which raises breaches of fiduciary duty and breach of trust. And in that claim, there's a meaty argument about the calculation of damages and how loss can be proved. So Lemuel's going to be tackling the subject of equitable compensation, taking in issues of causation in particular. And then finally, we have Daniel Petrides. He's working with Jonathan Seitler and Zoe Barton on a long-running professional liability dispute, which is heading for a lengthy trial next year. So Daniel's going to be finishing off our session with further points on equitable compensation. And in particular, he'll be bringing us up to date with how the Supreme Court case of AIB and Redler has been interpreted since it was decided in 2014. Now, one of Daniel's many claims to fame is that he appeared on University Challenge, and I know he loves it when people mention that. So I thought I'd get that in. And we've got our very own quiz for you today. We're going to be asking you in a minute a couple of questions in our poll, just to get us warmed up and to do a little bit of market research. So fingers on buzzers, we'll get that underway in a minute. Just before we start, I want to mention 2 points. We're keen to hear from you in other ways as well as through our poll, so please do use the chat function. Sorry, I've said that wrongly. Use the Q&A button. Please don't use the chat function. Use the Q&A button if you've got a burning question that you want answered. And you can ask your questions anonymously if you don't feel like putting your head above the parapet this early in the morning, and we'll try and tackle them as we go along. And finally, there'll be a feedback form that will pop up in your browser screen when the webinar's over. As ever, we really appreciate your views on what you thought of our session today, and equally what you'd like to see us cover in the future. So please do take a minute just to answer that questionnaire. So let's have our poll. We've got 2 questions for you, and they're directed at finding out how popular breach of fiduciary duty claims are in practice. So the first question is, has your firm, whether acting against or defending a professional, so whichever side you've been on, have you brought or defended a claim for breach of fiduciary duty in the last 3 years? Answer yes or no. This is designed to do a bit of market research to see whether these claims are actually being brought through the courts, because anecdotally it seems that they've been very much on the wane since the back end of the last financial crisis, and there's a reluctance to take the plunge and bring them before the court. So the answer is yes. 62% have brought or defended a claim for breach of fiduciary duty against a professional in the last 3 years. So that's rather more than we thought would be the case from the anecdotal evidence. So the second question is this: has your firm, whether acting against or defending a professional, threatened a claim or received a threatened claim for breach of fiduciary duty in the last 3 years? So this is designed to tease out whether there are claims that aren't actually being brought, but they're still being threatened in pre-action correspondence. Perhaps they're being mediated out of existence at the pre-action stage. We'd obviously have to ask follow-up questions to get at that information. But what we want to understand is whether it's more popular to threaten a breach of fiduciary duty claim and then to drop it at the point of having to plead it. And the answer is slightly more, so 73%, up from 62, I think the previous one was. So it is being threatened and then dropped, but not quite as much as we had anticipated, actually. So, well, let's see if we can start a renaissance and persuade you that there are benefits to pursuing these claims if you're able to do so on the facts of your case. And Jonathan's going to start us off with his opening remarks to get us going. And so over to you, Jonathan.
Thank you. My job here is to set the scene for Tiffany, Lemuel and Daniel. They'll be talking about causation and damages. I'm going to look at the portal to those issues and try to answer the question, what are the elements of a breach of fiduciary claim against a professional? What do you need to know about such claims to get them off the ground? The relationship between on the one hand, a solicitor and possibly an accountant or an auditor, indeed any professional who acts as an agent for a client, and on the other hand, the client, is a fiduciary one. And the reason why is because it's a relationship where the professional undertakes to act for a client or clients in circumstances which give rise to a relationship of trust and confidence. And such circumstances include situations like the professional receiving and holding money on behalf of clients, pending completion of a transaction, or holding funds of third parties on undertakings to use them for a specific purpose. And what we learned from the Ross River and Cambridge City Football Club case is that there are badges or indicia of fiduciary relationships which mark out the circumstances as ones in which fiduciary obligations arise. So those badges include things like inequality of experience, expertise and knowledge, where one party is dependent on the other's advice and integrity. Also, the professional having taken on responsibility, acting as agent for the client, or the professional having all the involvement in the task, or the professional having complete control of the task, or the professional being trusted with the discretion. All those aspects are badges of fiduciary relationships, and all those aspects are common features of professional relationships. And that leads us to an important proposition, which is that not all duties owed by professionals in fiduciary roles are fiduciary duties. And not all breaches of duty on the part of professionals are breaches of fiduciary duty. Even solicitors can still be negligent without being in breach of fiduciary duty if they misdraft a clause in a lease or another agreement. There's no question of a breach of fiduciary duty there. Even a solicitor who is the main example of a fiduciary can still be just negligent. And contractual and tortious duties don't become fiduciary just because the person who owns them happens to be a fiduciary. Fiduciary duties have also got to be distinguished from equitable duties of care. They are obligations imposed on trustees or other fiduciaries to use proper skill and care in the discharge of their duties. A trustee's duty to exercise reasonable care may be equitable and actionable in the equitable jurisdiction of the court, but it's not a fiduciary duty. It's only a breach of fiduciary duty which gives rise to the specific remedies that Tiffany and Daniel and Lemuel are going to refer to, which are things like imposition of a constructive trust, account of profits, and equitable compensation, which are important. The first two are gains-based and relate to the defendant's benefit rather than the claimant's loss. The first of which gives the claimant a proprietary interest over the property claimed, and the third of which has a host of advantages, equitable compensation over the measures of loss under common law, although, as Daniel's going to explore, those advantages may sometimes be overstated. Right, so that's the introduction. That's what fiduciary duties are compared to other common law duties. So when does it arise? A breach of fiduciary duty arises where call it the solicitor, acts contrary to his or her obligation of loyalty. It's all about loyalty. The principal is entitled to the single-minded loyalty of their fiduciary. And that loyalty involves acting in good faith, which means not with the intention of furthering the interests, for instance, of one principal to the prejudice of another, which is why so many of these cases arose in the lending context, where solicitors acted for both lender and borrower. Not placing themselves, the fiduciary, in a position of conflict, not allowing the performance of obligations to one principal to be inhibited by a relationship with the other. It's all about loyalty. And following from that, you need to be able to identify the specific obligation of loyalty that has been breached. Dishonesty is commonly involved in breaches of fiduciary duty, but in and of itself, it's not a condition of there being one. And a breach of fiduciary duty has got to be deliberate. There has to be a decision-making process. Blundering, inadvertent failures or unconscious omissions won't be enough. Now, just a couple of other points just to finish off this introduction. First of all, and Tiffany's going to be expanding on this, the fiduciary obligations of professionals don't necessarily end when the contract of retainer is terminated. The fiduciary will remain a fiduciary even if the relationship of trust and confidence continues, even if the professional retainer is terminated. And Longstaff and Birtles, a case from 2002, is the authority for that. Second point to bear in mind and always remember is that the professional may owe fiduciary duties to someone other than the party to an existing retainer. The case that supports this, perhaps rather surprising proposition, is called Conway and Ratiu from 2006, where a solicitor was found to owe fiduciary duties to the controlling company of an SPV client. Lord Justice Old pointed out that in a case where a fiduciary relationship arises out of a contractual relationship, it doesn't matter whether the person to whom a duty is owed entered into the contract directly or through an agent or through a nominee company. What matters is whether a relationship of trust and confidence has come into being. And you can take from that that the court may sometimes lift a corporate veil and find that the client owes fiduciary duties to the person standing behind the company or to an associated company. Last point, there's a case from 2004 called Morad and Al-Sarraj, which shows us that the fact that where corporate vehicles are used to carry out a transaction doesn't preclude fiduciary duties being owed between the individuals who control those entities if and when the agreement governing the distribution of profits in that case is signed by the individuals, not by the corporate entities. So key aspects at looking at the role of individuals behind corporate transactions are whether, if each party is operating through a company, those companies can properly be described as their corporate vehicle. And secondly, whether the money being contributed to the venture is advanced by the company or ultimately by the individual. And this principle, the Murad and Al-Sarraj case stands for, is an opportunity to bring in individuals to professional claims that otherwise, at common law, might be between the companies. So that is what I wanted to say by way of introduction. Hand back to Tiffany.
Yes, thanks for that, Jonathan. So I'm going to look a bit more closely at that Longstaff and Birtles case that you mentioned. And there, the claimants were looking to purchase a pub as a business venture and then instructed solicitors to act for them. Negotiations with the vendors were unsuccessful, and the claimants informed their solicitors they weren't going ahead with the purchase, so they terminated the retainer. And not long after that, the solicitors, who were in partnership with some others in a hotel business venture, suggested to the claimants that they might like to buy into that partnership instead. And the claimants agreed that that was a jolly good idea, and they signed the partnership deed. But guess what? The story doesn't have a happy ending. The business didn't prosper. The partnership was dissolved, and in fact, the claimants were left in financial ruin. And they brought a claim against the solicitors for professional negligence, for misrepresentation, and for breach of fiduciary duty of good faith, but duty of good faith between them as partners, not between them as solicitor and client. And under the prof neg part of the claim, they were alleging that there is a general retainer that had sprung up, which covered dealings with them as clients in respect of purchasing this hotel business. But that claim was rejected by the judge at first instance, who said the solicitors were under no liability to the claimants in contract. They owed them no duty of care in tort after the retainer had come to an end. And the claimants appealed, and they succeeded, but only after amending their pleading halfway through the hearing, halfway through the appeal hearing, in light of observations from the bench. And they added a claim for breach of fiduciary duty, and the Court of Appeal allowed the amendment. But in a rather scathing judgment from Lord Justice Mummery, he said the case powerfully demonstrated the importance of the paramount duty of a solicitor to observe fiduciary obligations in personal dealings with a client and even with a former client. So the solicitor proposing either to buy property from or sell property to a client was under a duty to cause the client to obtain independent advice, and that duty can endure beyond the termination of the retainer, which initially forms this professional relationship of solicitor and client. So, and unfortunately, as Lord Justice Mummery lamented, those principles are neither featured in the pleadings nor in the arguments in the court below. But in the end, the claimants did successfully claim that their former solicitors should have advised them to seek independent legal advice before entering into this partnership. And had they done so, the claimants would have taken that independent advice. They wouldn't have taken up the partnership proposal, and they were awarded equitable compensation to make good their losses. So always beware professionals entering into commercial ventures with their clients, certainly during the retainer, but in particular after the retainer has terminated. And this reminds me a bit of the case of Brown and Innovator 1. It was a mammoth judgment of the commercial court in 2013 that dealt with many, many things, amongst which was a claim against a firm of solicitors who'd held funds that were intended to be used in a tax scheme, which ultimately failed. And the claims against the solicitors for breach of trust and breach of fiduciary duty, they failed at first instance. Permission to appeal was given, but the appeal was never heard. But it's an interesting and it's a very instructive example of professional fiduciaries, solicitors in that particular case, getting closely involved in a commercial transaction to the extent that the partners in the firm took directorships in companies involved in the transaction. And that had rather unwelcome consequences ultimately. As Jonathan's mentioned, the most prevalent equitable alternative claims historically have been lender claims, usually where you've got mortgagees paid over money to solicitors in anticipation of completion of a property sale or a remortgage, and the solicitors have then prematurely paid away the money to a third party, and lenders have been unable to obtain adequate security for the loan in return. Now, as was addressed in the previous seminar, as a result of Mothew, a claimant now has a separate claim for intentional breach of the no inhibition principle, which dictates that the professional must act at all times in good faith and in the interests of each client. So this is what Jonathan was referring to in terms of intention. Prior to Mothew, it hadn't been necessary to establish that the fiduciary had committed a deliberate breach of this duty in order to establish a breach. Now there's a separate claim for an intentional breach of the no inhibition principle, which means consciously preferring the interests of one client over another. In Mothew, it was said that something approaching bad faith has to be shown to get home on breach of this duty, but not necessarily dishonesty, which is what Jonathan was just saying. So some fiduciary duties are strict. The duty of good faith is not a strict liability. In order to put a claim for breach of the duty of good faith, your pleading has to allege breach of that duty. And you've got to say in terms, the fiduciary committed a deliberate or intentional breach amounting to bad faith. And that's the Paragon Finance case that Caspar Belcher was referring to on the last occasion in our last seminar. Now, in practice, it's likely to be difficult to prove that there's been this conscious disloyalty, particularly without alleging outright dishonesty. You've got to show the fiduciary recognised that a conflict of duties arose and made a conscious decision to prefer the interests of one client over the other. And that can make it really quite difficult to advise a client whether to allege a breach of that sort of duty. It's difficult to advise on the merits, because the reality is, until trial and cross-examination, sometimes you won't know the likelihood of success. You've got to get inside the mind of the defendant. Did they take a conscious decision? And it may be for disinterested motives in some cases. So take the example of a solicitor who realises that they've got a duty to report a matter to a lender. They ask for the borrower's consent, which is refused, and they fail to report that matter to the lender because the borrower's a long-standing client of theirs. They've got an unimpeachable reputation. The solicitor's got no reason to doubt their client's credentials. In that scenario, you need to get to whether a conscious decision has been taken to prefer one client over the other, even though there's no dishonest motive, no dishonest intent there. So ultimately, if there's sufficient evidence to plead dishonesty, you should be pleading dishonesty. Breach of fiduciary duty should not be treated as a dishonesty light sort of alternative. So bearing all that in mind, why would you pursue a claim for breach of fiduciary duty? What are the benefits of doing so? Well, there's a combination of two particular features that makes it of interest to pursue a claim for breach of fiduciary duty. First is the flexibility of the remedy. It's possible to elect between remedies if alternatives are available. So if your client's got no interest in setting aside the underlying transaction, they can pursue compensation rather than rescission. And Daniel and Lemuel are going to deal with compensation. And secondly, the way that contributory negligence is treated in breach of fiduciary duty and breach of trust claims can make them very attractive. And those two elements are of particular significance in lender claims. So you'll most commonly see breach of fiduciary duty claims pleaded when there's been a financial crisis. The lenders want to pursue the separate equitable claim. The lender's got no interest in setting aside the underlying transaction. They want compensation. And they can take advantage of the rules on contributory negligence. So when you're looking at contributory negligence, you first of all look at the governing statute, so the Law Reform Contributory Negligence Act 1945, and that applies where a person suffers damage as a result partly of his own fault and partly of the fault of any other person. And fault for these purposes under the Act means an act creating a liability in tort. Now that doesn't include breach of trust or breach of fiduciary duty on the face of it. But then it doesn't on the face of it include breach of contract either. But as you may remember from your law school days, however long ago they may be, under the principles in Vester and Butcher, very unpronounceable Norwegian name, Vester and Butcher, where a claim is brought in contract as well as tort, contributory negligence is available as a defence if the defendant's liability in contract is the same as his liability in the tort of negligence. So in other words, if there are concurrent claims, then contributory negligence is available as a defence, because it wouldn't be fair for the defendant if his alleged misconduct gave rise to identical claims in contract and tort. but the claimant could avoid a defence of contrib if he only sued in contract and not in tort. So how does this all apply to fiduciary duty? So on the English authorities, the position regarding contributory negligence as a defence to breach of fiduciary duty is quite straightforward. It's not a defence to a claim for breach of strict fiduciary duty, as you could imagine. It's established also that it's not a defence to a claim for the breach of the no inhibition principle, where you've got this intentional element to the breach of fiduciary duty. It's said there isn't any scope for claiming a reduction. And we get that from the Nationwide and Bulmer-Radmore case from 1999, the lender claims before the last financial crisis. And interestingly, in that case, Mr. Justice Blackburn took the view that the rules for breach of fiduciary duty ought to follow the common law position by analogy. So he decided that because contributory negligence has never been a defence to an intentional tort, it shouldn't be a defence to an intentional breach of fiduciary duty. That was his reasoning. So if you're acting for a defendant, could it be said that if there's no reduction available where the breach is intentional, the defence should be available where the breach relied on is rather closer to common law negligence in substance, or where it's unintentional or it's innocent? Similarly, breach of trust claims, the conventional wisdom is contrib is no defence there, whether the breach was intentional or whether it was careless. But could you possibly argue the contrary? Because that would fit better with the but-for approach to causation in these types of claim that Lemuel's going to talk about, like a common law test indicating that we might be able to argue contrib should be available if the claim resembles this common law type claim. And it also fits with the Vester and Butcher case that I was just mentioning. If you've got concurrent negligence claims in tort and contract, could we argue that where the nature of the breach of trust is very similar to liability in tort, then actually the fiduciary should be permitted to raise the defence? And it seems that those ideas have gained some traction in other jurisdictions in New Zealand and Canada. And in Scotland, it was held to be arguable, at least, that contrib could be a defence to a claim for breach of the double employment rule. So that is something to bear in mind if you're acting for the professional on one of these claims, and you want to be able to argue that the claimant should shoulder some of the blame for the loss that's arisen, and if you fancy a trip to the Supreme Court to argue it. So we'll move on to tackle equitable compensation, causation issues just in a minute. I just want to set that up by saying that there is a difference between the common law rules and the principles of equity. And the cases on equitable compensation shouldn't be interpreted in any way as blurring those lines. So while some of the concepts and the terminology might be the same, and the structure of any analysis of liability and remedies is very similar, the rules are different. The but-for test of causation features, there's this requirement for common sense causation that's mentioned in target holdings in particular. And so many of the same factual matters that are pertinent to your common law damages claim are relevant to equitable compensation. But, for example, the principle of novus actus interveniens will not be applicable in a claim for equitable compensation, and the claimant won't be required to mitigate as such, as the term is used in law. But approaching it from a slightly different, more equitable perspective, if a loss arises from a beneficiary's unreasonable behaviour, for example, then that loss will be considered to flow directly from the beneficiary's behaviour and not from the breach of trust. So you might reach a similar result in a different way. So I'm going to hand over to Lemuel now, who's going to talk to us about equitable compensation.
Thanks, Tiffany. So, as we all know, AIB Group and Mark Redler and co solicitors still remains the seminal decision of the Supreme Court on how we assess equitable compensation. As Daniel's going to speak about a bit further, whether it's the last word on how these claims are sometimes assessed and calculated in practice is a slightly different matter. So, reminding ourselves briefly of the facts, in June 2006, Mr. and Mrs. Sondy applied to borrow 3.3 million from AIB, and that was going to be secured by a charge on their home, which at the time was valued at 4.25 million. That property was already charged to Barclays for £1.5 million, but that was in two separate accounts, one for 1.2 million and one for 300,000. Mark Redler, the borrower's solicitors, sought to redeem the Barclays mortgage, but they only redeemed one of the accounts. So there was still a balance of the 300,000 odd secured on the property. After various negotiations, Barclays did eventually agree that AIB could have a second charge registered. As was often the case in these sorts of claims around the time of the financial crisis, Mr. and Mrs. Sondy then defaulted on the loan to AIB, but Barclays repossessed the property and sold it for 1.2 million. They deducted their own charge and then gave the remaining mortgage monies equity to AIB, who therefore received around 870,000. AIB then commenced proceedings against their solicitors, claiming the full 3.3 million, but giving credit for the money that they'd received from the sale. Their argument was that once Mark Redler had paid out the money, that was a breach of trust, because they were only authorised to pay out that money if they could secure a first charge for AIB. They never in fact secured a first charge, although they did get a second charge. Mark Redler's case was that AIB was only entitled to the money that they would have got had the Barclays charge been fully removed. So that was approximately 275,000 after some deductions had been made. AIB had been brought claims for breach of trust, breach of fiduciary duty, breach of contract and negligence. At trial, they had succeeded on breach of trust, and the issue in the Supreme Court solely concerned the breach of trust and the calculation of how the equitable compensation was to be arrived at. As Tiffany has just mentioned, mitigation and contributory negligence don't, as a general rule, apply to claims for breaches of fiduciary duty or breaches of trust, and nor do the damages have to be foreseeable, since the idea is that because there is a fiduciary obligation that deals with the same concepts which foreseeability is meant to rectify. So the test is which losses were caused by the breach, and we determine that using hindsight and common sense. So how do we apply this test and consider the damages, the equitable compensation, which might be available for breach of fiduciary duty? Now, the first and the largest element is causation. And here we're concerned with the counterfactual. What would have happened if the breach had not occurred? Part of the rationale for this is that if we don't consider the causal connection, the beneficiary obtains a windfall, which is not the same as the profit that the fiduciary has made in another authorised fashion, and also doesn't reflect the loss that the beneficiary has suffered. And in Lord Toulson's view, that was a penal approach that is to be avoided. Lord Reid made the point that Tiffany made shortly before, which is that where third parties or the claimants have done something unreasonable, when we look at our common sense causation, we may take the view that actually the losses that have been suffered flow from those actions and they don't flow from the breach of the fiduciary themselves. And for Lord Reid, that was very important, because that was what meant that Mark Redler were only liable for the 275,000, because had they done their job properly, they would have achieved the first charge, and that would have meant that AIB would recover that extra money, but no more. Had Mark Redler done their job properly, there'd have been no question that AIB would have been able to get the whole 3.3 million back. They would definitely have still gone ahead with the transaction, as indeed they went ahead with it even when they got second charge. So, as we've said, it's about considering the counterfactual evidence of what would happen if it was actually performed. Now, this can be illustrated quite nicely by some examples of some recent case law, and it also shows the importance for the claimant in having a clear and hopefully strong claim in what they consider would have happened had the breach not occurred. Similarly, I think it's useful for defendants to give some thoughts to what counterfactual they might be arguing for if they're found liable for the breach. So one of these cases is Shah and Shah. There, one brother was deprived of his share of a business, and that was held to have been in breach of trust. His difficulty was that he said that had he been given his share, he would have used this to pay off other debts. On the evidence that was before the court, they considered that it wasn't possible to say that he would have done this, and therefore compensation couldn't be awarded on that basis. Another is Daniel and T, which was a claim against trustees for impermissible delegation on the basis that they had delegated their authority to select investments to their financial advisor and not properly undertaken their duties as trustee. There, again, the court considered that since the trustees, if they were acting properly, would have been highly involved in the choice for investments, but would have made sure that they were following and certainly at least taking into account very strongly the advice of the trained financial advisors who certainly were not parties to the claim and therefore were not being accused of negligence. The judge was unpersuaded that even if impermissible delegation had taken place, anything different would have happened, because ultimately the advisors would still have said, we think you should go into this investment and this investment. Even if the trustees had been exercising all of their powers themselves, they were very likely to have made the same decision and everything would have happened as it had gone on before. There is a fine line, however, to be careful between what would have happened and what could have happened. So it isn't open to a claimant to just put in potential hypotheticals of what could have happened and similarly without providing evidence. And similarly, a defendant can't say, well, if I'd arranged things differently, then I could have just made sure my actions weren't in breach and therefore no damages should, compensation should be allowable because I could have made sure that there wouldn't have been a breach. And that's a distinction that was drawn by the Court of Appeal in Auden, Mackenzie and Patel, which is a case that Daniel's going to talk about a bit more. But essentially, a director had sought to argue that there was no loss from his unauthorized drawings because he could have validly taken them as dividends from the company instead. The Court of Appeal considered that just because he could have done this did not mean he would have done, and therefore the appeal against summary judgment failed on that basis. But the assumed facts also went on to say that it should be assumed that he would have done it. And the court found that actually, if it was to be assumed that he would have done it, that was not suitable to make a negative determination on summary judgment, and that should await trial to see whether that could be established. So once we've looked at causation, another important factor to consider is the nature of the obligation that's been breached. As mentioned in the previous seminars with fiduciary duties generally, it's important to identify what the obligation is and how it's been breached. And where this really comes into play is in considering to what extent you need to be aware of the common law causes of action that the obligation might align with. Although the court was at pains to point out that the common law principles of causation for damages and calculation of damages as they exist in common law are not applicable. However, where there is an awareness that the equitable rules for equitable compensation can produce a result that's very similar to common law claims in certain circumstances. So a trustee might have three duties: one of custodial stewardship, to preserve the assets of the trust and not pay them out unless they're authorized to do so, a management duty to manage the trust property with proper care, and a duty of undivided loyalty. Now, breach of the custodial or managerial duty is commonly dealt with by an account. So you might remember where an unauthorized distribution is made, you can falsify or surcharge the account and put it back in and say, I'd quite like you to pay me that sum, thanks very much, because we need to reconstitute the trust. And that was AIB's case, that the duties had been breached, an account had to be given, and that meant paying all the money back that had been paid out in an unauthorized fashion. Here's where there's a bit more divergence between Lord Toulson and Lord Reid, who both gave reasoned judgments. So Lord Toulson, taking the analysis of Tipping J and Bank of New Zealand and New Zealand Guardian Trust, noted the three other duties of a trustee, or three ways that the trustee can breach their duties, which is directly causing damage to the trust property, infidelity, so conflict of interest, and care and skill. Obviously, as Jonathan said, most of the time, if there is a pure breach of the equitable duty of care and skill, that is not a breach of fiduciary duty. So although Lord Toulson considered a breach of or breach leading to damage to the trust property would ordinarily result in the restitution of that trust property, there was still a concept of causation, even if it was stringent causation, i.e. the claimant only has to show that the but-for test has been achieved. There isn't any of the same issues as in common law calculations. Also, the misapplication of the trust monies did not create an immediate debt. All it meant was that there was conduct meriting equitable compensation for loss, which might have been caused, but that loss still had to be assessed. Where, as was the case in AIB, the trust was no longer subsisting and was a commercial trust, Lord Toulson took the view that it did not make sense to apply the traditional trust remedy of an account to reconstitute it, where the commercial purpose had already been achieved. And therefore, in these cases, the kind of compensation which should be awarded should at least bear some similarity to that which was awarded for breach of contract, because the trust is part of the contractual machinery. Lord Reid very much does not want to go that far and spends quite a lot of his speech making it clear that although you might get a similar result, the rules are really quite different, and analogies are not helpful and should not be used. Instead, he based his decision on a slightly narrower view, but still part of what Lord Toulson had said. Where compensation is required to rectify breach of trust, as we've discussed, there's still a requirement of causation. And because the court has to assess matters in the round at the date of the trial, this means that you can use evidence after the date of the breach to determine what that loss was. Accordingly, applying both of those meant that actually the breach was only the 275,000. There is therefore still a bit of tension about the relationship between the common law claims and equitable compensation. The very basic idea is the same, i.e. to rectify the wrongful conduct, but the application is quite different, as Lord Toulson was, as Lord Reid, was at pains to point out. The third option to consider is the date on which compensation is to be fixed, because as we've pointed out previously, you are assessing things with hindsight at the date of the trial. As part of the common sense approach, this means that changes in value since the date of misappropriation or breach can be taken into account. Now, in the most recent version of Lewin, it's suggested that you can move around this date. The court can take the view that it might be necessary to set the date earlier than the date of trial to appropriately calculate the loss for the breach of fiduciary duty. Now, that accords with Lord Reid's statement that what the court is doing is determining what is required to put the beneficiary in the position as if there had been no breach, echoing Lord Brown-Wilkinson's statement in Target Holdings. The figure is assessed at trial, but does not have to be the figure of the loss that exists at trial if it would not properly compensate the beneficiary for the loss caused by the breach. And Daniel's going to speak about this a bit further, but this can mean that in situations where you can make an argument that a fiduciary is in continuing breach or has made further breaches since the initial misappropriation or breach, adequately compensating the beneficiary means you do need to consider what the value may have been at an earlier time. One good example of this is in Ray Ahmed. Their shares had been transferred in breach of trust and then subsequently returned, but had lost value by the time they were returned, and the court was trying to determine how to calculate the loss and what date should be used for the loss of value. The court held that that date should be the date where it could be established they would have been sold by the joint trustees in bankruptcy, but taking into account what I've just said about hypotheticals, that was a later date than when the shares first could have been sold, because the court was satisfied that the fourth trustee in bankruptcy would not have taken the necessary the first trustee in bankruptcy, would not have taken the necessary steps to sell the shares, and therefore that was not the appropriate measure of loss. Now, the last point from AIB is leaving open the question of whether different considerations apply in fraud. Although there haven't been any large decisions dealing with this since AIB, so an important case on this that predates AIB is Gwen Valley Development Co Limited and Koshi. There, the Court of Appeal was considering a similar counterfactual scenario, but this time involving a breach of a duty of disclosure and a breach of the duty that had been found to be dishonest. Having come to the view that the same thing would have happened even if the disclosure duty had been complied with, the Court of Appeal gave very short shrift to the idea that there should be some separate test of compensation, of causation, in cases of fraud. Although, of course, there were still gains-based measures of damage of compensation available, and an account of profits was ordered. AIB is therefore a good reminder that although in abstract a claim for breach of fiduciary duty can promise significant sums above the common law causes of action, this isn't always the case, although it can certainly ease some of the burden in terms of proving the calculation of compensation and avoiding some of the more thorny issues about mitigation and foreseeability that would otherwise be a bit more difficult. On its own, however, causation can still hide many sins, and where causation rules are in play, there are cases where you may end up with a very similar figure of loss, even though the procedure is different. And as AIB themselves found out, it's not always as attractive or expensive as claimants might wish. And that's all that I've got to say about actual compensation, but Dan's going to take us up to date with how this has been interpreted at the present day.
Great, thank you. Well, with the benefit of Lemuel's very helpful summary, it sounds as though AIB is probably bad news for those looking to bring a claim for breach of fiduciary duty, and conversely good news for those on the receiving end of one, because the claimant's recovery may well end up being far no more generous than it would be under a conventional tort or contract claim. But despite it being a robust and binding decision of the Supreme Court, AIB is not quite the end of the story. As many of you will remember, it was very controversial at the time, as indeed was Target Holdings, and it remains so. And it's therefore perhaps unsurprising that the Court of Appeal has, as it were, fought back in 3 subsequent decisions, and I'm going to briefly talk about those. The first is Various Claimants and Giambronean Law. It's a decision from 2017, and like both Target and AIB, it was a case concerned with solicitors acting in breach by paying away money advanced as part of a property transaction. The facts, however, were slightly more exotic than both of those cases, and bear repeating. The claimants purchased tried to purchase, I should say, 185 off-plan holiday homes in a development in Calabria, the boot on the end of the Italian leg. Under the purchase contracts, which were governed by Italian law, the deposits were strictly non-refundable. The purchasers advanced the deposit monies, some of which were as much as £100,000, to the defendant solicitors who were acting for all of them, with instructions not to pay out the deposit sums until certain title guarantees required under Italian law, indeed created, I understand, by legislation meant to protect purchasers of off-plan holiday developments such as these, with instructions not to pay the sums out until those guarantees had been provided by the developers. The developers did eventually provide some guarantees, but they were not quite in the correct form, but nonetheless, the solicitors still paid out the deposits. And as you might have guessed, things subsequently deteriorated. First, it transpired that there were some problems with the planning permission for the development. Then, the Italian police seized the development as part of an ongoing investigation into alleged money laundering by both the IRA and the Italian mafia. And I should add at this point that the solicitors, despite being specialists in the Italian property market, had failed to warn the clients about the apparently quite real risk of organised crime being involved in these kind of developments. Unsurprisingly, the claimants rescinded the contracts and the purchases collapsed, but they were unable to recover the deposit money, so they sued for the deposit amounts and at first instance obtained summary judgment for them. The case went up to the Court of Appeal. Now, factually, the difference between these facts and those of both Target and AIB seems wafer thin. You've got defendant solicitors who've paid out sums advanced on trust before the preconditions for doing so have been met. And you've got losses which were in fact caused by an event distinct from the breach of duty, whether it be the fraudulent inflation of the price in Target, the property crash in AIB, or the apparent criminality of the vendors in Giambrone. Indeed, the solicitors in the Court of Appeal said that the first instance decision should be set aside because this was just a straightforward AIB case. Even if they had performed their duties to the letter, the losses still would have accrued, and as such, their liability should be nil. But perhaps surprisingly, the Court of Appeal disagreed with Lord Justice Jackson, who literally wrote the textbook on professional liability, giving the leading judgment. And there are 2 points that are worth noting. The first is that it was held that both Target and AIB were distinguishable. This was because the role of the defendants was not to take any active steps on behalf of the claimants, such as registering the charge and target or discharging the prior charges in AIB, but rather to passively act as the custodians of the monies until they receive the appropriate guarantees. And although the reasoning is slightly abbreviated on this point, it seems that this is because different counterfactuals are said to arise. If you have a trustee who is a mere custodian, then Lord Justice Jackson is saying the appropriate counterfactual will be one in which the money was simply never paid out. So the remedy should just be that amount of money being given back to the claimant. Whereas if custodianship is combined with a duty to carry out a positive act, the appropriate counterfactual will be a scenario in which the positive act was carried out correctly, which brings us back into the sort of AIB mode of thinking. Now, this might seem like a fairly tenuous distinction, and it seems to me that it probably is, but nonetheless, as things stand, there seems to be binding Court of Appeal authority that this is the correct way to conceptualise such claims. And this in turn leaves it open to the ingenuity of the parties to find creative ways of characterising the scope of the duties owed. That also brings us to the second point of note. The Court of Appeal also confirmed, for what I understand is the first time, of the relevance to equitable compensation claims of the decision of the House of Lords in, and I should take a breath here, South Australian Asset Management Corporation and York Montague Limited, fortunately better known to most of you by the acronym SAMCO. Now, while the application of SAMCO seems like a logical extension of the apparent collapsing of the distinction between equitable compensation and common law damages in AIB, it also creates its own difficulties. As you will all know, SAMCO is a case which the courts have found very difficult to apply. It turns on another fairly imprecise distinction between, on the one hand, the provision of information, and on the other hand, the provision of advice. In an orthodox negligence case, what's known as the SAMCO cap operates to exclude the recoverability of losses, which would have been suffered even if information provided had been true. Whereas, even if information provided had been true, whereas a party providing advice will be liable for all foreseeable consequences of that advice being wrong. Recently, Lord Sumption in Hughes Holland and BPE solicitors reformulated this distinction as one between so-called Category 1 cases, corresponding to the information situations, and Category 2 cases, corresponding to the advice situations. And he emphasised in BPE that solicitors will normally fall within the more restrictive Category 1. So, if SAMCO applies, this would seem to be a further limitation on the consequences for which defendant professionals will be held liable. However, on the facts of Giambrone itself, it was in fact held that the solicitors were within Category 2. Lord Justice Jackson emphasised that this was an unconventional conveyancing situation. He said the purchasers had no knowledge of Italian law. They were wholly reliant on the solicitors to tell them what protection they needed, what sums they should pay out, and when the sums should be paid out. The difficulty with this analysis seems to be that much the same could be said of almost every English property transaction, almost every property transaction in which solicitors act. So it seems to chafe slightly against Lord Sumption's analysis in Hughes Holland and BPE. Now, one way of squaring the circle may be to focus on the fiduciary character of the relationship in Giambrone, as opposed to the common law negligence cases of Hughes Holland and SAMCO itself. Indeed, some of you may have detected a similarity between the quote I just read out from Lord Justice Jackson and the factors which Jonathan listed at the start of this fiduciary and the principle, or the conferral of authorities and discretions. If so, that might be taken to mean that despite SAMCO technically applying to equitable compensation claims, in general, the SAMCO cap will not be engaged. Conversely, in one of the very few cases applying Giambrone, a decision of HHJ Halliwell from last year called LIV Bridging Finance against EAD solicitors, which was another case involving a failure to register a charge in a property transaction, it was held that SAMCO did in fact come to the rescue of the solicitors who were found liable on summary judgment for a much smaller sum than they otherwise would have been. Conscious of the time, the second decision I can take slightly more quickly. That's another decision of the Court of Appeal. It's called Interactive Technology Corporation and Firster. The case unusually concerned the true construction of a court order, and specifically the use of the words equitable compensation in that order. The defendant, who was a former solicitor of the claimant, a former director of the claimant company, had dishonestly caused that company to pay excess remuneration of at least £4 million to him over a number of years. And this was obviously a very clear breach of his fiduciary duties, and he was found liable at trial. At a consequentials hearing following the trial, when counsel for the successful claimant, our colleague Alan Gorgie QC, as it turns out, sought an interim payment of the equitable compensation, he was met for the first time by the slightly surprising submission from his opponent that such a payment would be inappropriate because it was uncertain whether the company had in fact suffered any losses on the AIB approach to calculating equitable compensation. The matter ended up in the Court of Appeal, where target and AIB were once again distinguished, and it was held that the term equitable compensation is in fact a very broad term, which is not necessarily restricted to reparations for losses. It was suggested by Lord Justice David Richards, that in some contexts it may have the narrow compensatory meaning given to it by Lord Toulson in AIB, but in other contexts, such as claims involving traditional trusts and claims like Firster involving dishonesty, it may be appropriate to construe it more broadly as a specific remedy for reconstitution of the depleted trust fund, so the defendant was liable to pay the sums back. Now, while in many professional negligence cases it may be quite difficult to argue that the context requires the latter broader construction to be adopted, this does again seem to open the door to creative arguments by parties. It raises some quite interesting questions in cases that do involve issues of dishonesty or slightly more unusual trust arrangements, and is also a further example of the Court of Appeal apparently straining not to apply AIB literally. Finally, as Lemuel intimated, I'd just like to briefly mention another decision of David Richards, Lord Justice David Richards, as it turns out, in Auden, Mackenzie and Patel, which funnily enough was another summary judgment case. The defendants were the sole directors and shareholders of the claimant company and had caused it, again in breach of their fiduciary duty, to pay over £13 million to intermediary companies in Dubai controlled by them, which subsequently paid the sums onwards to defendants themselves. It seems that the purpose was to basically avoid paying any UK tax or evade paying UK tax. The defendants raised the rather bold defence to this that the company had suffered no loss because had they not unlawfully procured the payments to the Dubai companies, then being the directors and shareholders, they would have simply lawfully paid the sums to themselves as dividends. In other words, applying the but-for analysis as per Target and AIB, their liability, they said, should be nil. Now, as Lemuel suggested, this argument was rejected, but in doing so, the Court of Appeal went slightly further than perhaps it needed to, and held that equitable compensation in cases such as these, in such cases, but-for causation could not be extended to cover assumed or hypothetical scenarios. Rather, Lord Justice David Richards described Target and AIB as, and I quote, restricted to circumstances where the beneficiary obtained the full benefit for which it bargained, or where if the trustee had fully performed its obligations, the loss would have been less than the amount of the unauthorised payment made by the trustee. In other words, the incursion of those cases onto the traditional principle of equity that trustees are required to reconstitute trust funds in specie is, according to Auden at least, limited to narrow situations broadly analogous to the actual facts of Target and AIB. If correct, this is obviously potentially a very far-reaching limitation of the application of the Target and AIB principle, and one which, it must be said, doesn't appear to be entirely supported on the judgments in either case, and particularly AIB. If the custodial duty of a trustee or a professional trustee will only be transformed into a lesser remedial obligation in the two narrow situations described in Auden, the equivalence between common law damages and equitable compensation will be further eroded, and the scenarios in which AIB bites could be much rarer. As Auden is a relatively recent decision, we will have to see how this plays out. But in the meantime, it seems difficult to escape the conclusion that the Court of Appeal is not particularly happy about AIB, and for parties willing to be creative, the decisions mentioned create some scope for circumventing its strictures, while what seems to be the prevailing judicial mood may result in further encroachments being made in the near future. And I'll hand back to Tiffany at this point.
Great, thanks, Daniel. Yes, we're bang on 10 o'clock, well done. It's interesting that some of the cases that you mentioned are summary judgment applications where a breach of fiduciary duty has actually been pursued successfully at the summary judgment stage. So, yeah, did you have any thoughts as to why that might be?
Well spotted. I suppose it arises from some of the things you were talking about. I'd imagine that some of the absence of certain defences, the lack of some of the limitations that might make a contractual or tortious claim slightly more difficult, such as things around mitigation and foreseeability, the absence of those perhaps mean that if you've got the right fact pattern and a fair wind and a sympathetic judge, you've perhaps got a slightly better shot in some cases at getting summary judgment on a fiduciary duty claim. But obviously summary judgment is notoriously difficult to predict.
Yes, oh, it's very interesting. Well, thank you to all of our panellists, and thank you all very much for attending our webinar today. As I mentioned at the start, we've got a short questionnaire that's going to pop up in your browser once the session is over. We'd really appreciate your views on how you found our session today and any topics that you want to put forward for consideration in the future. And just a reminder that a recording of this seminar is available shortly on our YouTube channel, which is, if you search Wilberforce Chambers in the YouTube search bar, then you'll find us. Okay, well, thanks very much, everybody, and we look forward to seeing you next time.